Possibly our biggest module for this week is Chapter 6, Legal and Ethical Considerations. Starting off with some basic definitions. The first would be ethics. This is the study of philosophical beliefs about what is considered right or wrong in society. Think back to Socrates, Plato. And not to be compared with bioethics. These are ethics specifically used in relation to ethical dilemmas surrounding healthcare. And by dilemma, we mean this is a conflict between two or more courses of action, each with favorable and unfavorable consequences. And you'll run into these ethical dilemmas every day in nursing. Unfortunately, there is very few days where every situation is going to be completely cut and dry. You're going to see many situations that have both positive and negative aspects. And you as the nurse really got to use that judgment to do the best thing for your patient. Some other definitions, both pertinent to mental health as well as every aspect of nursing. These are also definitions I could almost guarantee you're going to see again next semester in leadership. So it's best to just go ahead and learn them now. The first will be the concept of autonomy. This is respecting the rights of others to make their own decisions. These patients have a right to informed consent. We tell them both the pros and the cons, the benefits and the dangers of each procedure, and allow the patient to make their own decisions. The next would be beneficence. This is the duty to promote good, not to be confused with non-malfeasance, and this is doing no harm. Then we got justice, distribute resources of care equally. Fidelity, maintaining loyalty and commitment, not lying to your patient. And veracity, one's duty to always communicate truthfully. So fidelity would be, if you tell your patient you're going to do something, follow through with that. You're going to see that a lot in mental health as well. Comes up a lot. An example I always use is a lot of dementia floors. You will see nurses that will lie to their dementia patients when really you should not. Even if it's something inconsequential, even trying to calm the patient, telling them the family's coming and will be here later. That could be an ethical violation. So again, fidelity, maintaining loyalty and commitment, following through on what you say, and veracity, always telling the truth. And there could be many aspects of these definitions you'll see. One issue would be non-malfeasance. If tests are not useful, then the potential harm outweighs the benefits. And again, one of our central tenets is non-malfeasance, do no harm. Other predictive psychiatry, stigmatization, genetic testing could prevent an individual from getting a job. That's another big area that's very new, is the fallout from all of this genetic testing. And the absolute privacy that goes along with genetic testing. What if you get a genetic test comes back and shows that you have a massively increased rate for heart disease or cancer? Would you want to know? What if their insurance company finds out? Is your insurance company going to want to keep you on their rosters for very long? Probably not, unfortunately. Another issue of autonomy, the right to know or not know of genetic tendencies in health. If you found out you were going to die tomorrow, would you want to know? And that's a very real consideration. How would that change your life? You found out you have 1 year to live. How drastically is that going to change your outlook and how you live every day? Next, we'll move on to mental health laws. And mental health especially is an area of nursing that has a lot of legal considerations. And another thing to keep in mind while we're talking about this is that both your textbook and NCLEX is a national test. So they're going to be teaching you national standards. The laws surrounding healthcare are governed by the states, and what you can do in one state can be wildly different than what you can do in another state. And both your textbook and NCLEX are teaching from a national standpoint, something that is true for all 50 states. So just because you can do it in Texas or do it in Ohio does not necessarily mean it is something you can do on the test. First, we'll talk about the admission procedures and the different ways that a patient could find themselves on your floor. As we've touched on a little bit, there is two different types of admissions, a voluntary admission or an involuntary commitment. This involuntary commitment, that's what we call a pink slip here in Ohio. That is that 72-hour hold written by the doctor. And your underlying concept there is going to be that danger to self or others. Severe mental illness, gravely disabled. And that danger to self or others is going to be that key defining characteristic of this. Another example would be an emergent commitment, that temporary admission. And this would be in the case of a patient arrives at your facility severely injured, severely confused, severely deep in dementia. And these patients are unable to consent to treatment, but at the same time, we treat them under a concept called implied consent. This is going to be different than that 72-hour hold where that doctor has written an order to hold this patient for 72 hours as they've been identified as a danger to themselves or others. All right, so thinking of these different forms of admission, which individual may need involuntary hospitalization? Which of these patients are we going to pink slip? Which one's getting that 72-hour hold? Would that be a person with alcoholism who's been sober for 6 months but begins drinking again? B, an individual with schizophrenia who stops taking prescribed antipsychotic drugs? C, an individual with bipolar disorder, manic phase, who has not eaten in 4 days? Or D, someone who repeatedly phones a national TV broadcasting service with news tips? So out of these, which one is the most severe danger to themselves or others? And that answer is going to be C, that patient who has not eaten in 4 days. As you can imagine, there's some serious legal considerations in this 72-hour hold. You could categorize that as kidnapping. You are holding that patient against their will, denying them their freedom. That's a central tenet of the Constitution, habeas corpus. You have that right to a trial, not to be held without trial. And it's used when patients believe they've been held without that just cause. They can challenge that unlawful detention. You need to make sure that you are documenting very carefully for all of these patients. Same thing with restraints. You are denying that patient their freedom. And we also need to make sure that we are using the least restrictive option possible. As many of you already know, I'm sure a lot of you are already working out there in the bedside, working out in the medical field. There's a lot of different forms of discharge procedures as well. First, there's that unconditional release, termination of the legal patient-institution relationship. This is just your classic discharge. This patient has come in, they've completed treatment, and we're sending them home. The next would be that AMA, against medical advice. This came up a lot for me. I spent a few years working dialysis. And patients on dialysis have to have that treatment to live. Without that dialysis treatment, that 3 hours a day, 3 times a week is their only kidney function. And you would have patients come on, sit for an hour, and decide they want to go home. And it creates major issues of this patient has the freedom to decline this treatment, but they're also risking death without that dialysis. And you really need to make sure you're explaining the dangers to this patient with them leaving AMA. Other things, such as conditional release, usually requires outpatient treatment for a specific period of time with follow-through evaluations. The patient's being discharged from their inpatient psychiatric facility on the condition they're following up with their outpatient meetings with their therapist, with their psychiatrist. And then there's also assisted outpatient treatment, similar to conditional release, but court-ordered. Some basic patient rights. One is the right to treatment. Next is going to be the right to refuse treatment. And 3 is the right to informed consent. As we've said, this patient has a right to know both the benefits and the dangers of every procedure. They are an active participant in their own care. That patient's informed of the risks, benefits, any alternatives they could take to your proposed treatment. The patient must voluntarily accept that treatment. Say they're coming in unconscious. You can then treat that patient under the concept of implied consent. You can then say you had a minor patient who is unable to consent for themselves. A minor comes in with a broken arm. And the parents aren't with them. You are able to treat that patient under the concept of implied consent, under the premise that you can assume that parent wants treatment for that child's broken arm. You can assume that unconscious patient wants treatment. Our case study. J.S., a 27-year-old male, is court committed by his parents to your unit with a diagnosis of paranoid schizophrenia. He lashes out at staff when they attempt to give him his medication. He states, "You're trying to poison me." J.S. continues to argue with staff. He's not aggressive, but refuses all treatment. Legal and client's rights are suspended when a client is hospitalized involuntarily. Is that true? False? Depends on the state? Or it depends on the physician assessment? And that answer is B. Even though he is pink slipped, that patient still has the right to refuse that medication. That patient still retains their rights. They can be on that 72-hour hold. They only force medications in the case of a danger to themselves or others again. That is an absolute last resort, and you need to be very careful with that as well, because medications are a form of restraint. You know, these sedatives, these antipsychotics, these are a form of restraint, just like hard restraints, just like seclusion. The family of JS asks, if you can force him to take his medication, how should you respond? And that answer again is no. We cannot force him to take his medications. He has every right to know both what he's receiving, know the benefits and the risks of that medication, and he has every right to respond, whether he's on an involuntary hold or not. Other rights will be that rights regarding psychiatric advance directives. And just like medical advance directives, there's many different forms. There's the living will, and then there's also the healthcare by proxy. A living will is a written document that the patient writes while they're of sound mind of what treatment they'd like to receive should they be unable to make those decisions. The other form is going to be a healthcare by proxy, and that is someone you designate, someone you trust to make those decisions for you. And one quirk I see come up a lot in NCLEX questions is, does that healthcare proxy have to be a family member? And the answer is no. That healthcare proxy can be any person you trust to make decisions for you. Other rights, as we've already touched on, is those rights regarding restraint and seclusion. You have to have doctor's orders, and there you have to be very, very closely documenting this. In an emergency, a nurse may place that patient in seclusion or restraint, but then immediately go to the doctor and get that order. You are able to put them in a restraint if they are a severe danger to themselves or others, but immediately go get that order as soon as possible. And orders for restraint and seclusion are never written on an as-needed or standing order basis. The doc can't just write you a standing order, put anybody in seclusion you want. No, that has to be on a immediate, individual, situational basis. Just like every other area of the medical field, these patients have an absolute right to privacy. This is under federal law. We've all heard of HIPAA, the Health Insurance Portability and Accountability Act. These patients have a right to privacy about their medical treatment. Other aspects of confidentiality are social media. You see this more and more. You'll see TikToks and Vines online of nurses posting patient stories. Usually they are not getting too specific, but even that, I would not even glance off of a patient situation online. You are setting yourself up for serious litigation and problems. I worked at a previous college. We had a student who was making TikToks at clinical. Apparently they had a family friend who knew that patient. That patient's family is very upset that their family member is in the back of her TikToks online. The facility found out. The patient's family is very furious, and it became a major situation for all of us involved. Also, confidentiality after death. That patient's right to privacy does not stop after death. And finally, confidentiality of professional communications. You have a duty to make sure that their charts stay secret. We actually had a major issue. It's also regarding to you as the nurse. Can you just go open up your own chart? That's against a lot of hospital policies. I know I've never worked at a hospital that would let me open up my own chart, and I was both a patient at the Cleveland Clinic and worked at the Cleveland Clinic. Another major issue that would come up with people accessing charts unauthorized. We have a lot of sports teams. LeBron James is in the hospital. Where does LeBron James? Where do all the athletes for the Cleveland Browns, the Cleveland Indians go to get their treatment? They go to the Cleveland Clinic. And they also are very aware that people are going to be curious. When you log into their chart, there is a record of that. I actually had on our floor, we had a lot of our PCAs. There was a major story in the news up there where a child was seriously hurt in a child abuse case, and it was all over the news. The PCNAs at night pulled up the child's chart. They were let go at 7:30 a.m. as soon as everyone was in that morning. Us working in the mental health field, we do have one exception to this absolute privacy rule, and that is that duty to warn and protect third parties. If a patient comes in and tells you they have homicidal ideations of killing their neighbor, there is an ethical legal duty on the hospital's part to notify that person that this person is saying they want to kill you. Also, child and elder abuse reporting statutes. These are also your absolute legal duty to report. Any instance of child abuse and any instance of elder abuse, you have a legal obligation to report. If you have any hint of child abuse, any hint of elder abuse, you have a legal obligation to report that, and it's always going to be on that test, either reporting it to your charge nurse, reporting it to the doctor, or reporting it yourself, making sure that is reported. It's not to say that other forms of abuse aren't horrific. Domestic abuse. There's lots of different forms of horrific abuse out there, but child and elder abuse are the two forms that you are legally bound to report, because those are considered the two cases where they are unable to report for themselves. Let's talk about other laws relevant to the psychiatric nursing. Back to our friend J.S. Eventually he agrees to electroconvulsive therapy, ECT, which I believe we talked about in a previous chapter. Which member of the team is responsible for obtaining the client's informed consent? Is that A, the physician, B, the psychologist, C, the case manager, or D, the registered nurse? And that answer is A, the physician. The physician is responsible for obtaining that informed consent. Your role as a nurse is to both make sure it's obtained, make sure that you can verify that patient is aware of what they are signing, but it is the physician's responsibility to actually obtain that informed consent. And that comes up a lot as well. We actually had a local hospital up here, and a patient came in to the ER, received an emergent EGD. Then down the road, they decided to sue that hospital. Well, eventually, as they were doing the paperwork, it found out in the rush to save that patient's life, they did not get an informed consent signed from that patient. And case closed. Getting into the legalese, the first would be a tort. This is any wrongful act, intentional or accidental, that results in an injury to a patient. And then deeper in that would be an intentional tort. This is willful or intentional acts that violate another person's right or property, such as assault, battery, false imprisonment, invasion, privacy, defamation of character, slander, libel. Anybody know offhand the difference between assault and battery? Assault is just a threat, versus battery is actually striking someone. You know, one of the students in the room threatens to throw their water bottle at my screen right now. That is assault. Versus they actually stand up and chuck it. That is battery. False imprisonment we've touched on a bit already, and it's going to be very pertinent for us in the case of involuntary holds, restraints. Invasion of privacy. Again, any of those violation of those HIPAA and privacy laws. And finally, defamation of character, slander versus libel. A real easy way to break those two down is slander is spoken, libel is written. And this is any untrue statement about a person that's spoken is slander. Any untrue statement about a person that's written is libel. The vast majority of what we're going to be dealing with in the healthcare is going to be unintentional torts. These are unintended acts against another that produce injury or harm. Because there's very rare that a nurse has actually purposely harmed a patient. It's normally going to be in the form of negligence, of them not watching that patient as closely as they should, or malpractice, them deviating out of their scope of practice. You know, your major examples, this is going to be in the case of falls. You know, patients fall, and we have a duty to monitor those patients. Even if that is not always possible, it is your responsibility to be watching that patient and preventing injury wherever possible. And also keep that within state laws as well. Here in Ohio, a big example that comes up for us is the difference between hospitals and nursing homes. Hospitals and nursing homes have two different regulatory bodies here in Ohio. In hospitals, I bet alarm every patient. If there's even a risk of them being a false risk, I bet alarm that patient every single time to protect myself if I even have a hint that they're going to get up and they could fall and hurt themselves. Versus nursing homes. They do not at all. That patient has a right to fall. It's considered restraints to put the bed rails up. Not even all four, just putting two bed rails up. If that patient is not able to get out of bed with two bed rails, that is considered a restraint. And these nursing homes will put that bed all the way to the floor, stack mattresses all around the bed, while still keeping the bed rails down. They also consider seat alarms and bed alarms a form of restraint. And it really comes into some very legal, dangerous issues of where does the benefit outweigh the risk? When are we a restraint to that patient versus when are we protecting that patient? And you really got to make sure that you're good with both your state laws, your regulatory laws, as well as the specific policies of your facility. In order for that patient to sue you and the facility, they need to prove 5 things. 1, you had a duty to care for that patient. 2, you breached that duty. You did not follow through on your obligations. 3, your failure to follow through on that duty caused that injury. 4, proximate cause, was your breach of that duty likely to be a foreseeable cause of that injury? Could you have predicted that your breach of this duty would cause that injury? And 5, that actual damages occurred. If they can't prove those 5 things, then they do not have a case. Where do your standards of care come from? And your scope of practice as a nurse come from your state board of nursing. And again, that's what makes these national textbooks a little hard. That makes them a little gray area because the state scope of practice can vary wildly. Your laws from state to state can vary. Other areas would be professional nursing associations, institutional policies and procedures, and the custom as a standard of care. What is the normal procedure as nurses? Can this be used as evidence of a standard of care? In the absence of a written policy, did you use common sense? Your next audience response question is to reiterate, which of the following identifies the titles that registered nurses will use and what they are legally allowed to do? Would that be A, state boards of nursing, B, professional organizations, C, custom as a standard of care, or D, institutional policies and procedures? And that answer is A, the State Board of Nursing. That State Board of Nursing is who issued you your nursing license. They are saying what you are identifying yourself as, a registered nurse. Acting on questionable practice. You as a nurse have a duty to report violations. Everything from negligence, irresponsibility, suspected impairment of a fellow nurse. You have a duty to intervene and a duty to report these violations. Everything from incompetence, again, impairment, any criminal activity. And your reporting process to present actual harm. You have to document clearly and accurately first. And your answer is going to be report that to your supervisor. If the supervisor is unavailable, you can then move that up the chain of command. I'm betting you already had a big module on documentation back in your foundations course. Just to reiterate, that documentation needs to be accurate, complete. You need to be objective. Leave opinions out of it. We are sticking just the facts. Means of interpersonal communication. The patient has a right to review this record. This patient can request their medical records and read everything you've written about them. Though that record does belong to the institution. And I can't stress enough, accurate, objective, sticking to the facts for timed, dated measurements. You're also going to hear a lot of instances of chart reviews, reviewing that documentation. And retrospective record reviews are used for quality improvement. See what we could have done in this situation to improve the quality of care. Also be used as evidence, used for risk management purposes, and used to determine insurance reimbursements. In the case of evidence, in the case of you have to go to court, records are used to determine the extent of the patient's damages and suffering as a suit. And remember, if you didn't chart it, it didn't happen. Everything you do for that patient needs to be documented. You could change every dressing on time, but if you didn't document it, it did not happen. The nature and extent of the injuries in the abuse cases, nature and extent of physical and mental disability and disability cases, and the nature and extent of injury and rehabilitative potential in worker compensation cases. These are legal records, and you really need to have that in the back of your mind when you're documenting on every single patient, that these are legal records that could be used against you. There are a lot of benefits to electronic documentation. I'm old enough, I might be one of the last nurses that actually did paper charting at a facility. There's a lot of, I personally kind of liked paper charting. I could get really accurate, very descriptive about each individual patient case. But there is a lot of benefits to electronic documentation as well. It's going to be much more legible. It's going to be much easier to access for both the providers and the other members of the healthcare team. Manages data and communication to reduce errors. Facilitate decision making. You've got your policies and procedures right there. You got your drop down boxes with your options for documenting that patient. Federal privacy laws around access. Courts assume if it's not documented, it didn't happen. You also have specific rule and time frames for correcting errors. It'll also give you warnings if you forget for an error. For us, our documentation system would give us a series of warnings that this med was not documented, this med has not been given, and that goes a long way in preventing errors. The next is forensic nursing, and this is going to be a broad term. And basically, this is just nursing that has any aspect of dealing with criminal law, dealing with the legal system. This could be everything from these forensic nurse practitioners working with the county coroner's office. These could be the SANE nurses, sexual assault nurse examiners. This could be any aspect of nursing. This could be those nurses that work with the law offices to audit charts for them, because those lawyers don't know what's going on in a medical chart. They have nurses and professionals that review those charts for them and are very trained at picking out even the slightest error you could make. And there will be many factors at stake when we start dealing with patients in the legal system. Everything from the patient's competency, individual's fitness to stand trial, were they on an involuntary commitment, and are they responsible for the crime that they committed? Nurses must participate in setting policies that create and maintain a safe environment. You have a duty of both beneficence and non-malfeasance to that patient. Always document that patient's potential for violence. Document their demeanor, document their affect, document spoken words, verbatim, in quotations. Communicate these observations to colleagues. When you're giving that handoff report, make sure you are giving a good, thorough report on each patient. If there was a patient that presented a danger, you would want that report if you were walking out on the floor. And new laws enhance criminal charges and penalties for striking nurses and other healthcare workers in the course of duty. That's going to vary state by state. I know that legislation is still pending in Ohio. That is a newer thing is that patient striking a nurse a more serious penalty than if they struck a different civilian? And it does open up a serious discussion of, is that creating more harm to the patient? Do nurses get special privileges? When it comes to striking a nurse, is that worse than committing violence against anyone else? And wrapping up, our audience response question. A nurse was the case manager for a client with serious mental illness for 6 years. The client died by suicide 1 week ago. Today, the client's spouse asks, I always wondered if my spouse was a victim of sexual abuse in childhood. What can you tell me about that? Can the nurse disclose information to the surviving spouse? That answer is B, no. That patient still retains the right to privacy even from their spouse, even after death. Again, I know we threw a lot of new definitions and concepts at you. At the same time, you're going to see these come up a lot, both in mental health as well as your leadership course. I can guarantee you're going to have these legal definitions within your ATIs. And again, it's always make sure you're understanding the underlying concepts of those. They may have you have to pick between the difference between slander and libel. Slander is spoken, libel is written. You're going to have to pick between, is that beneficence or non-malfeasance? Did you have a duty not to harm that patient, or did you have a duty to do good for that patient? Because they like to throw that at you, because they're similar sides of the same coin, but they are different. And again, if you have any questions on any of these terms or any of these concepts, shoot me an email. Shoot me a text. I'm happy to jump on the phone, answer any questions you have while studying. Make sure, there's no stupid questions. There are no bad questions. I'm happy to answer anything you're unsure of. Otherwise, I'll see you here in Chapter 7.